Okay, good afternoon, everyone. Welcome. This meeting of the 5th Judicial District Court Judicial Nominating Commission is now in order. This meeting is being held pursuant to public notice provided on March 24th, 2023. My name is Camille Carey. I am the Dean of the University of New Mexico School of Law. By New Mexico Constitution, the Dean of the School of Law is charged with the responsibility of serving as chair of judicial nominating commissions. I do not vote except to break a tie. Shortly, I will ask the members of the panel to take the oath of office prescribed by the New Mexico Constitution, which requires each person serving on this judicial nominating commission to pledge to discharge the duties of the office of commissioner faithfully and impartially. Please allow me to briefly describe the meaning of impartiality in this setting. According to the Handbook for Judicial Nominating Commissioners, written by the American Judicature Society, commissioners should be aware of their own points of view, those of fellow commission members, and those inherent in the evaluative criteria they use. By maintaining an awareness of prejudices, commissioners will be able to avoid biased results. In essence, impartiality for judicial nominating commissioners means a willingness to be open-minded and objective. Previous knowledge of an applicant is not a reason for disqualification. You should, commissioners, however, disclose any current or past professional, family, business, and other special relationships with the candidates. Please disclose the nature of the relationship and state whether you can be impartial. In addition, any information of a negative nature that may be known about an applicant should be brought up during the individual's open interview, and the information provided should be sufficiently specific to provide a meaningful opportunity for the candidate to respond. Justice Julie Vargas will administer the oath. You should raise your right hand and repeat. Justice Vargas, will you please administer the oath of office to this commission?
You'll all stand, please. Repeat after me, raise your right hand. I state your name.
I, Julie Carey,
Solemnly swear or affirm
solemnly swear or affirm
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and the Constitution and laws of the state of New Mexico,
and the Constitution and laws of the state of New Mexico,
and that I will faithfully and impartially
and that I will faithfully and impartially
discharge the duties of the office of Commissioner
discharge the duties of the office of Commissioner
for the 5th Judicial District Court
for the 5th Judicial District Court
Judicial Nominating Commission,
Judicial Nominating Commission,
on which I am about to enter
on which I am about to enter
to the best of my ability.
to the best of my ability.
Thank you.
Thank you, everyone. Please sign the oath form that was provided to you and hand it to Beverly. She will take care of notarizing it.
Okay. David.
Commissioners, now it is time to do introductions. Please introduce yourselves, indicate the identity of the person or organization who appointed you to this commission. Also, this is the time to disclose whether you have a special relationship with any of the applicants, the nature of that relationship, and whether you can be impartial. We will start with Justice Vargas.
Good afternoon. I'm Julie Vargas. I'm a justice on the New Mexico Supreme Court. I was appointed by Chief Justice Shannon Bacon, and I do not know any of the applicants today.
Good afternoon. I'm Lee Kirksey. I'm one of the district judges here in Lovington. I was appointed by Chief Judge Mark Sanchez. I do know each one of the applicants. They all regularly appear in front of me as attorneys, but I do not have any special relationship with any of them, and I believe I can be impartial in this matter.
Thank you, Judge.
Hi, my name is Luke Ragsdale. I'm from Roswell. I was nominated by the State Bar and judges. I haven't met any of the candidates until today.
Hi everyone, my name is Chelsea Green. I'm an attorney in Roswell as well. I was nominated by Governor Lujan Grisham, and I do not know any of the applicants today.
Christopher Mills, attorney in Hobbs. I'm also an elected city commissioner for the city of Hobbs. I was appointed by the State Bar judges. I know all three of the applicants in professional capacities and social capacities. I've, over the years, had professional and social contact with all the individuals fairly equally, and I can be fair and impartial in these matters.
Thank you.
I'm Lucinda LaRoe. I live in Hobbs and I teach at Lovington High School. I was appointed by President Pro Tem Stewart. And I know I recently made the acquaintance of Ms. Kuykendall because her mother attends the Episcopal Church where I play the organ. And I had met about 8 years ago Mr. Cortez when I went to the city manager's, attorney's office looking for some help.
Thank you. And can you be fair and impartial?
Yes, ma'am.
Thank you.
I'm Mark Stout. I'm a lawyer in Hobbs, New Mexico. I was appointed by House Speaker Martinez. I don't have any personal relationship with any of the applicants, and I believe I can be fair and impartial.
Thank you.
Good afternoon. District Attorney Diana Luce. I was appointed by the State Bar and Judges. I do know all three applicants. So I'll start with Lisa Kuykendall. She was a prosecutor with our office for a number of years, and so I do know her well. I believe I can be fair and impartial. I do know Kristen Dickey. She was opposing counsel, public defender, and she was also a prosecutor with our office. And her husband was also a prosecutor with our office, and he is her husband is now a contract attorney that does training for attorneys with our office, but I believe I can be fair and impartial. And then I do know Ephraim Cortez. I've known him since he came forward at the city attorney's office in Hobbs. We've worked together on matters relating to our office in the city. And I communicate with him, not like every week, but frequent enough that I believe that I can be fair and impartial.
And Ms. Lewis, did you say who appointed you? I'm sorry.
State Bar and Judges.
Okay, thank you very much.
Megan Kirtley, I'm Assistant District Attorney. I was appointed by the State Bar and Judges. I know all three applicants. Ms. Kuykendall, as Ms. Luce said, worked in our office when I was a victim advocate. I had to try cases with her and assist her with that. I also had a personal relationship with her during that time when we eat meals together, things like that, but I do believe I can be fair and impartial. Ms. Dickey, the same thing. She was an attorney in the office. When I was an intern, I would write for her. We would go and do things together. I also know her husband. He was my Bridge the Gap mentor, but I do believe I can be fair and impartial. Mr. Cortez, in the same capacity as Ms. Luce, I contact him frequently with cases that I need assistance with, and our cases sometimes coincide, but again, I can be fair and impartial.
Thank you.
I'm Thomas Jennings. I'm from Roswell, and we all know where that is. I was appointed by Speaker Martinez, and I know none of the applicants that I'm aware of, and I will do my best to be fair and impartial to all.
I'm Patrick Collins. I'm from Roswell. I was nominated by Governor Michelle Lujan Grisham. I do not know any of the three candidates, and I feel I can be fair and impartial.
I'm Anna Martin. I'm also from Roswell, and I was appointed or nominated by President Pro Tem Stewart, and I'm familiar with Ms. Kuykendall. Sorry, I mispronounced your name every time. And as opposing counsel on a family law case, and that's it. And I believe I can be impartial.
I'm Joe Baca. I'm a judge on the New Mexico Court of Appeals. I was appointed to the commission by our Chief Judge, Patrick. I don't believe I know any of the applicants, and I can be fair and impartial.
Thank you. Thank you, everyone. We have a quorum. The next item of business is the adoption of the agenda. Upon the conclusion of all of the interviews, it will be this commission's decision by motion and vote whether to hold discussion of the candidates in open or closed session. But at this time, we are just looking at whether we are willing to adopt the agenda included in your materials. Do I have a motion to adopt the agenda?
So moved, Madam Chair.
Thank you. Is there a second? Thank you. All in favor?
Aye.
Opposed? Abstentions? Thank you. The agenda passes. We are here to recommend applicants to Governor Michelle Lujan Grisham to fill the vacancy due to the retirement of the Honorable Judge William Shoebridge effective May 1st, 2023. Is it May 1st? May 1st. Okay. On March 24th, my office began taking the following steps in actively soliciting applications for the vacancy. Sent notification in the form of a press release which included instructions for obtaining an application and the application deadline of Thursday, May 11th, 2023 at 5 o'clock to the New Mexico Press Association, Albuquerque Journal, Albuquerque Business First, Debaca County News, Hobbs News Sun, and the Roswell Daily Record. We also posted notification on the Judicial Selection website. We sent notice to the New Mexico State Bar, which sent notification and application procedures to each member of the State Bar residing in the state. My office also posted notice of the vacancy and application procedures on UNM School of Law's alumni job posting service, and email notification was sent to all law school alumni who met the statutory qualifications. Notification was sent to the following voluntary bar associations: the Bar Association of the U.S. District for the District of New Mexico, District Judges Association of New Mexico, Curry-Roosevelt County Bar Association Grants, Lee County Bar Association, New Mexico Black Lawyers Association, New Mexico Defense Lawyers Association, New Mexico District Attorneys Association, New Mexico Hispanic Bar Association, New Mexico LGBTQ Bar Association, New Mexico Trial Lawyers Association, New Mexico Women's Bar Association, New Mexico Criminal Defense Lawyers Association, and the 12th Judicial District Bar Association. We requested that members of the Nominating Commission appointed prior to the application deadline make every effort to identify qualified applicants and place telephone calls to encourage them to apply. After the application deadline expired, a news release was issued May 11, 2023, announcing the names of the applicants for the position and the date of this commission meeting. On May 11, 2023, my office sent the names of the applicants to the Chief Disciplinary Counsel to determine whether the applicants had received disciplinary charges. The Chief Disciplinary Counsel responded in a letter dated May 12, 2023, stating that none of the applicants had been the subject of formal disciplinary charges or received any discipline, public or private. On May 11, 2023, my office contacted the Chief Clerk of the Supreme Court of New Mexico to inquire whether the applicants had ever received discipline by the Supreme Court and whether the applicants had ever been the subject of formal disciplinary charges. The Chief Clerk responded on May 16, 2023, and indicated no formal discipline by the New Mexico Supreme Court has been filed against any of the applicants. The applicants and commission received notice of this meeting, an agenda, the names of the applicants, an interview schedule, and information about the interview process, a copy of the statutory qualifications, and a copy of the rules governing judicial selection commissions. In addition, each commissioner received the completed applications submitted by the applicants. Pursuant to Article 6, Section 35 of the New Mexico Constitution, this commission must send the names of the nominees to fill this position to the governor within 30 days of the occurrence of this actual vacancy. Since this vacancy will exist as of May 1st, 2023, this commission must send the names to Governor Michelle Lujan Grisham by May 31st, 2023. I actually intend to communicate this commission's decision to the governor as soon as possible today upon adjournment of this meeting. The following criteria for evaluating the candidates can be found in the rules governing judicial nominating commissions: physical and mental ability to perform the tasks required, impartiality, industry, integrity, professional skills, community involvement, social awareness, collegiality, writing ability, decisiveness, judicial temperament, and speaking ability. These criteria come from the Handbook for Judicial Nominating Commissions and are in addition to the bare statutory qualifications. The Commission will use these criteria to guide its decision regarding whether to recommend the candidates to the governor. The next item of business is the adoption of the schedule of the interviews. Is there a motion to adopt the proposed schedule?
So moved.
Thank you. Second?
Second.
Thank you. Discussion? All in favor?
Aye.
Opposed? Abstentions? Unanimously passes. Each applicant has 30 minutes allotted. I will limit the interview to the scheduled time for fairness between applicants. Each applicant has an opportunity to make an opening statement of up to 5 minutes if that applicant so chooses. Each commissioner will be limited to one question with the potential for follow-ups if there is time remaining. Because we have a limited amount of time with the candidate, if your question has already been answered, please don't feel pressured to ask a question and instead cede your time. If needed, I may interrupt a candidate so that we can stay on schedule. Any letters of recommendation received prior to the scanning of the application have been included with the appropriate application. Letters received after that point were scanned and sent to the commission by email. Today you have been provided with a complete list of reference letters. We are now ready to allow public participation. If members of the public would like to participate, please come up to the table, state your name clearly, and limit your comments to no more than 5 minutes. I will keep time and I will cut you off at 5 minutes. Hi, the floor is yours for 5 minutes. Please state your name.
Hello, my name is Nick Maxwell. I'm a Lee County resident, and I welcome each of you today. Those of you who have come from out of Lee County, welcome for making the trip down here. Really appreciate it. Some of y'all came a much further distance. Today, I am just here to give a couple of my opinions. I'm very appreciative for the opportunity to offer public input today and for your solicitation. I really think that's part of a good government structure, and transparency is one of the best parts about our government and one of the privileges that we all get to continue to share because we make sure that the government's open. And so as such, I offer my thanks again. I have requested the applicants' documents that were submitted before you, and I've reviewed them myself. And although I do not offer support for any one of them, I would tell you that each of them are upstanding individuals and offer great contributions to our community, and they're very productive every day, I believe. That being said, I have seen in one of the applications, and without stating any names, because I do not know if it's completely true, the instructions state to submit your completed application and signed application. And after my review, I've seen that one of the applicants has not signed their application. I don't know if it's completely true, but the records I got indicated that was the truth, and that the other two applicants did sign. And so I would ask today that be considered. Down here in the 5th, we'd like to keep a lot of our cases in here, and we don't really want to send them off to the Court of Appeals. We would like to make sure the details are paid very close and careful attention to. Thank you very much for listening today, and I'm excited to hear the interviews.
Thank you. Are there any other members of the public who would like to comment? Okay, if there are no further comments, we will proceed to interview the applicants as scheduled. Applicants, you must leave the room prior to your interview. Also, friends and family of the applicants who are observing may not report information about the other applicants' interviews to the applicants. And then applicants, once your interview is complete, you are welcome to stay and watch the remaining interviews. So we have our first applicant, and the other applicants need to leave the room at this time.
Madam Chair,
Yes.
as a point of order, I think it would be appropriate that no member of the audience be able to make any comments or clap or anything for any of the candidates if they so choose. I think that it should be quiet. Maybe that's okay, but I'm not sure, but I just don't think that we should allow comments from the audience.
Thank you, that is the case, and that is a good point. The public participation aspect of this proceeding is now over. And so anyone who remains here through the public parts of the commission, we may or may not go into closed session later. Please do stay quiet as we proceed. thank you for the point of order. Mr. Cortez, welcome.
Thank you.
You have 5 minutes to make an opening statement if you so choose. I will keep time and I will rudely interrupt you at 5 minutes if you are
Understood.
not done at that time.
Yes,
And then we'll
ma'am.
proceed with questions. The floor is yours. Welcome.
Thank you. Good afternoon, Dean Carey, Justice Vargas, and members of the Commission. Thank you for giving your time to be here this afternoon. My name is Ephraim Cortez. I'm the son of a career criminal defense attorney and an elementary school teacher. I'm the result of a patient father and praying mother. I'm also a husband and father. My wife Elaine is the preacher's daughter, and that preacher is a former sergeant in the United States Army. Needless to say, I walk a straight line. My wife and I share a loving home with our 8-month-old daughter, Layla, and our 2 dogs, a miniature schnauzer named Termite and a Yorkie named Brinkley. In case you're wondering about the power structure in our home, it goes Layla, Brinkley, Elaine, and Termite and I share a space somewhere down here at the bottom. I've lived in Hobbs my entire life, except for the years that I attended college and law school. As a second-generation attorney, I've grown up in New Mexico courthouses. As a matter of fact, the old courthouse across the street used to have a law library that I would play in while my dad was in court. I'm a student of the philosophy of Stoicism. I believe in the cardinal virtues of courage, temperance, justice, and wisdom. I strive to practice self-discipline daily and firmly believe that my practice of self-discipline has afforded me an enhanced personal and professional life. I have been the recipient of outstanding mentorship. I would be remiss if I didn't take the opportunity to acknowledge some of those mentors this afternoon. First, my father, Ruben Cortez, who taught me that every person deserves representation no matter what they've been accused of. He also taught me to have empathy and compassion for people as an attorney. He taught me trial work, and he taught me never to be too aggressive with an adverse witness, that is, until the jury gives you permission to do so. Craig Labrie, former Judge Labrie, who taught me he who knows the rules wins the game. He would take 2 hours out of his day every day to discuss the rules of civil procedure with me for the first 6 months of my practice. Tara Wood, who taught me that trial begins and ends with jury instructions. Mike Stone, now Judge Stone, a true gentleman and a scholar. He taught me you'll win some cases you should lose, and you'll lose some cases you should win. He also taught me how to conduct myself with wisdom as an attorney, and he taught me that he who angers you controls you. I began practicing law in 2012. I conducted my first trial about a month or so after I was licensed. It was a landlord-tenant case, and I was scared to death, but I desperately needed the $500 that Craig Labrie offered me to conduct a 2-day trial. I finished the trial, my clients were happy with my work, and in reflecting on my fear in that trial, I realized that that fear has kept me coming back to the courtroom and to trial work. It was then that I realized that fear is a powerful force. It can drive you to excellence or paralyze you into mediocrity. I've chosen to allow fear to be my driving force forward. Since that trial, I've tried cases at virtually every level in New Mexico, from municipal court to federal district court, and in courthouses in between. I've practiced law in a multitude of disciplines, including criminal law, personal injury law, civil rights law, and various others. I've worked on both sides of the aisle in both criminal law and civil law. Yet still, I have a healthy fear or reverence for the courtroom and for the law. And it's armed with this reverence that I sit before you today. I know that being considered honorable is not a title you can give yourself. It's a title that others bestow on you. I only hope that my work ethic, empathy, and legal abilities allow me to earn that title. Thank you again for your time, and I'll stand for any questions.
Thank you. Our first question will come from Justice Vargas.
Good afternoon, Mr. Cortez.
Good afternoon.
Thank you for your application. One of the new challenges that judges in the judiciary are facing these days, it's a big one and it's an important one, is the challenge to the rule of law. And what I'd like like to know is how do you plan to address challenges to your authority? And can you point to something in your resume or in your background that gives us some sort of comfort that you'll be able to adequately address those challenges?
Yes, ma'am. And so thank you for the question, and I would agree with you. There have been plenty of times where I've sat in a courtroom and thought to myself, what happens if the litigants just choose to ignore what the judge instructs them to do? What I can tell you is I've been before various judges and they've all had different approaches. Some work effectively, others not so much. My approach is rooted in stoicism, of course, and I believe in temperance, and I believe in not allowing my emotions to get the better of me, especially when challenged, because I think it's in those moments that you have to really exude temperance, because if you don't, it only discredits the court, it only discredits the process, and I believe it's the people's belief in the validity of the process that makes the process strong. And if I were to lower myself down to engaging in arguments with litigants or attorneys, then I believe I've discredited the court and thus hindered the process.
Thank you.
Yes.
Judge Kersey?
I know Ephraim and have worked with him on a variety of occasions around here. And Ephraim, I'm curious, and this is a tough question you get.
Sure.
What are some flaws of yours that you think you'll need to overcome to be a good judge?
Sure. Thank you, Judge Kersey, for the question. I think maybe overanalyzing situations. And so I promised the law school professor if I was ever in the position to demonstrate through his lesson, I would do so. So if you'll bear with me just a few seconds. The law school professor was a mentor of mine, and he told me that the difference between a Supreme Court judge, a Court of Appeals judge, and a district court judge is the ability to make a decision rapidly. He said district judges are required to make decisions with fast pace because you have more cases. So he tells me about a hunting trip that 3 judges go on. It's a Supreme Court justice, a Court of Appeals judge, and a district judge. Out of respect to the Supreme Court justice, the first 2 judges, they're hunting pheasant. The first 2 judges allow the Supreme Court justice to get the first shot off. Pheasant comes, the Supreme Court justice watches it, never shoots, and he turns to the other ones and says, I don't know if that was the right breed of pheasant. Next one is the Court of Appeals. Same thing happens. Court of Appeals judge said, I don't know if that was a male or a female pheasant, so I don't know if we can take it. Next comes a district court judge. Bird flies, judge fires 6 shots, turns to the other ones and says, was that a pheasant? So I think that demonstrates the need to make a decision. And to come back to answer your question, I will have to temper my need to be absolutely correct in every aspect of the case and make a decision.
Thank you for the answer.
Yes, ma'am.
Mr. Redfield?
Thank you. Good afternoon, Mr. Cortez.
Good afternoon.
That's a great story, very true. So your comments on Stoicism are very interesting. How do you think that your study of Stoicism would benefit you on the bench?
So I appreciate the question. I think it would, without a doubt, benefit me because some of the cardinal disciplines like temperance or discipline, self-discipline itself, I think are important because we all receive 24 hours in a day, and it's how you use that time that really matters. And in order to effectively use your time, you have to have self-discipline. So my day currently starts at 3 a.m. And generally ends about 8:30, and then I start panicking if I'm not in bed by 9. But it is that self-discipline that allows me to sit in the chair, read the briefs, make a decision, and get an order out. And I think, I've talked to some litigants, and they knew that I was applying, and I can tell you from Las Cruces to Albuquerque, the sentiment seems to be the same. Just make a decision, and let us appeal it if we're going to appeal it, but just make a decision. So again, Stoicism, one of the cardinal tenets would be discipline, and I think that would help. Yes, sir.
Ms. Green?
Thank you. And thank you for your application. And I'm going to piggyback on your answers to Judge Kirksey's and Mr. Ragsdale's question because I think it's you know, you probably know attorneys are extremely busy, the court dockets are extremely busy. Can you give some practical examples about how you will go about trying to get decisions out quickly, managing your docket? I think you talked about your background and how that might help, but just practically, what are some steps that you'll take to actually do that?
Sure. And so it's my understanding, and I don't have the exact number of what Division 3, how many cases Division 3 currently has pending, but it's my understanding it likely is above 600. And so what I would have to do is stay here, do the work, read the briefs, rather than maybe go home early, you know, and I'm not accusing any district judge, present or not present, of going home early. But it is so vital to give the due time to the cases and to have an interest in the case and to respect the time of the litigants as well, because you know, I've been in that situation where you've litigated your case and you're waiting a year for an order, and that holds your case hostage or holds it in limbo. And I can only imagine what your clients are telling you when you're on that side of it. So again, it is so much rooted in discipline and getting the job done.
Mr. Mills?
Everyone is entitled to a fair public hearing in front of an impartial tribunal. Can you expand upon that? What does that mean to you, and what does that mean to the system, and how will that be assured in a potential future courtroom of yours?
Yes, absolutely. And so there are times where certain cases become high profile or make it into the media or are highlighted in the media. I think the important thing for a court to do is to ensure that the public sentiment doesn't permeate the court and doesn't taint the decision or the evidence or the process that's allowed in the trial. Now, certainly, I know that gag orders are very restrictively used, and so I wouldn't propose to ban the media from a courtroom. But it would be incumbent on me to make sure that I am actually regulating what evidence is put and make sure that it is truly a part of the case and not based on public sentiment or not something that would otherwise excite the case or taint the issues. So I think it is so much regulating evidence, time, and process.
Thank you.
Ms. Laurel?
Well, you mentioned the value of healthy fear in the courtroom. So what would be the thing that a new judge should most fear?
Oh, that's a great question. I would say fear and respect may be closely akin to this, but it would be getting up to speed. Now, as a lawyer, I can tell you I've been in front of plenty of judges, and before I even thought of applying for a judge, a couple of thoughts crossed my mind. One, I would never apply to be a judge. And two, the judge doesn't know what they're doing. Clearly, the judge doesn't get it. So I think the healthy fear or the reverence part of it would be get up to speed. I know that with my work ethic and my dedication to the task, I can get up to speed. But as a new judge, former lawyer, you've only speculated at this point. It's not until you put the robe on and sit in the seat and start calling cases that you really understand the gravity of what you're doing. And so there is fear, there is reverence, but I think that's countered with work ethic and dedication.
Mr. Stout?
Yes, Mr. Cortez, in our recent society here, there's been seems like a great push for judges to accept or push their own moral or political views into their decisions over what the rule of law is, or in line with what Justice Vargas was talking about. Very evident from your background, your family background, your personal moral beliefs. If they're at odds with what the rule of law is, or what the stated law is, what are your feelings or thoughts in that regard of how you would rule?
Excellent question, Mr. Stout. And so I've actually thought about this at great length. I believe the answer lies in my judicial philosophy. And my judicial philosophy is judicial restraint. Now, as you stated, I am personally, I'm rooted in Christianity. And that's where I derive a large amount of my strength, or all of my strength from. However, I am also an avid supporter and believer in the rule of law. So judicial restraint would require me to put aside my personal beliefs and follow the law. Now, that's not to say judicial activism doesn't have its place in the courtroom. As a matter of fact, early on, my father and I we had a case, State versus Granville, and it's a trash can case. And it stands for the proposition that Article 2, Section 10 provides greater protections to individuals in their garbage. And it breaks from Fourth Amendment precedent. And the reason why I bring that up is because what it took to have that case determined was a bit of judicial activism at both the district court level with the district judge and at the Court of Appeals level. So certainly judicial activism has its place, but I think we can all agree that too much judicial activism, especially for somebody that's rooted in their Christian faith, is dangerous. It could be dangerous. And not just for Christian judges, but for any judge, because that's a concentration of power that I think the founders of our Constitution didn't intend. So to answer your question directly, I would put aside my Christian beliefs and follow the rule of law as written.
Thank you.
Yes, ma'am.
Ms. Luce?
Thank you. Ethan, good to see you. Thank you for applying.
Yes, ma'am.
My question is, since COVID, we've had backlog of cases, getting them through the system. The Supreme Court has been very open to being creative in resolution of cases, and they have allowed some pilot programs of settlement conferences for criminal cases. Tell us kind of what your philosophy is on being open or having ideas for how to handle backlog and how to move cases through the system in a fair process.
Thank you for the question. I think the idea of a settlement conference for criminal cases is great. And I can tell you, as you know, in civil cases on the federal level, you have mandatory settlement conferences for every, as a matter of right, for every civil case that's pending. Now, we've been in dockets where you have a 50 case trial docket, and when it's time to go to court, your case could be number 12, and then suddenly you're number 1 because the cases start pleading out. I think there's likely a more judicious and economical way to do that, and I think settlement conferences would be that. Also, with COVID, I saw our courtrooms really become innovative with the advent of Google Meets or virtual hearings. I'm not too young that I don't remember the days when district judges, under no circumstances, would allow telephonic conferences, under no circumstances would allow continuances, and really stuck very strictly to the schedule. I think a little bit of leeway, virtual hearings, allowing telephonic appearances could help as well clear up the backlog. The important thing is get the cases before the court, however you need to, and get them heard and get them decided. Now I say that, but I also know the flip side of that coin, as Judge Kirksey's staring at me. I know the other side is sometimes lawyers abuse that, so you have to kind of temper your implementation of that. But to answer your question directly, you need to get the cases before the court and get them heard, however that is.
Ms. Curley?
Can you give an example of incivility in the courtroom or in practice, and how you as a judge could prevent that and such occurrences appearing in front of you?
Excellent question, Megan, and I'll tell you that I think some of our district judges at least have informed me, some of our magistrate judges have informed me that the level of incivility that they witness now pales in comparison to what they used to witness 10 years ago, 15 years ago. I think fear drives a lot of incivility. I've been a part of very litigious cases where opposing counsel make slights. I was called incompetent by opposing counsel in one case. I think it's important to know to exercise restraint in those situations for all attorneys. But to answer your question more directly, I think mentorship goes a long way. I mentioned Judge Stone mentoring me and teaching me how to operate in wisdom, and I can tell you that that served my career and has served my career to this day richly. And I think likewise, a judge sits in a unique role that he or she can have that conversation with litigants and level with them and explain to them where a high level of incivility may end for their career. I've seen some of the most foul approaches to litigation. And one thing that I've always realized is those careers often don't last long. And I think a judge is in a great position to have that frank conversation with attorneys.
Mr. Jennings?
Mr. Cortez, in your opening statements, you talked about being proud of your family, and it's obvious you're proud. Your family would be proud of you for today. And thanks for your application. And you know, today in the social media and the news media, we see the far right, we see the far left, two opposites. The people in the middle, which I think most Americans are left out. I'm not a lawyer, but I'm here because I want to make sure that that you're fair, impartial, and your collegial attitude toward your opposition and to the courts and to the community is important to all of us, because that's what makes America great.
Yes.
How would you manage your courtroom to make sure that you're fair, impartial, collegial, and the other attributes that enhance your court and the system?
So, Mr. Jennings, I appreciate the comment preceding your question. And I agree with you. The political times seem to be more divisive than I can remember, and certainly, you know, some of my relatives that grew up in the '60s would say, you know, this isn't nothing. But the way that I feel is the division in society is at a peak. What I can tell you is that doesn't belong in the courtroom. Because I think when you allow division or extreme views to permeate, or you partake in that as a judge, we've lost the independence of the judiciary at that point. I think one of the most incredible things about the way that our country is built, is framed, is the separation of powers. And it would be important for me as a district judge to understand my role as a judge, as a representative of the judiciary, is not to forward the agenda of the legislature, or not to forward the agenda of the executive, or not to forward the agenda of a party. It is to govern the rule of law in the case that's before me, and I would be dedicated to that task.
Thank you.
Yes, sir.
Mr. Cortez, in following up on Tom's question, in recent years we've seen a variety of people from within law enforcement and related to criminal and civil justice stating opposition to different laws or regulations that are going on. And during COVID, we saw the governor's public health orders come to be questioned. And they were challenged, and in the Supreme Court, they were upheld as having the rule of law. As a justice, you said you'd have the term Your Honor, and you'd have a role also outside of the courtroom itself, a bigger role, I believe, in society. What role would you see appropriate for a judge to take in clarifying when those kinds of rulings have clarified where a dispute has been existing?
Sir, Mr. Collins, I appreciate the question. And I think the answer to your question lies in educating the public on the role of the court. Because I think what we witness sometimes is the pressure for judges who must seek re-election to either champion one side, oppose one side, or champion the other side, or oppose the other side. And I think that's dangerous precedent to set for the court, for a judge. And so if I'm understanding your question correctly, it's how I would conduct myself in public. And so the important thing for me is to understand that I don't just represent the judiciary when I have the black robe on and I'm sitting on the bench. I represent the judiciary at all times. And how I conduct myself in public matters. And the things that I say in public also matter. And they can be attributed to the judiciary. And so being cognizant of that, I think, is important. So sometimes, in keeping with the philosophy of Stoicism, sometimes the best thing to say is nothing at all. And so exercising restraint and temperance, I think, would be the best approach for me.
Thank
Ms. Martin?
Thank you. Thank you for your application. I heavily practice in domestic relations law, and I noticed in your application that that's probably one area where you lacked experience. Do you have a plan in place for, a crash course in that area of law, and specifically how to deal with the fact that in a lot of those cases, both parties are pro se, and what your role as a judge is within that?
Sure. And so to answer your first question, Ms. Martin, the crash course would be work. It would be sit at my desk, read, study. I know that there are materials that the JEC puts out that would help give a precursor. I also have a law library at home that has a great deal of domestic books. Actually inherited it from an attorney whose primary practice was in domestic law. So I would get myself up to speed. I would conduct the necessary research. I would read the pleadings before me. But I don't think it's just to make myself competent. I think the litigants deserve that. And so putting that effort in, I think is not only a responsibility of the judge, but it's an honor to serve those litigants. And to your second point, pro se litigants. I can tell you that I've prosecuted many cases that are pro se in the municipal court. There is a contract defense attorney, but certain cases, a due process doesn't require appointment of an attorney. Those cases are unique. They present their own challenges. But I think what I've witnessed and what I've been able to do to kind of make those cases go a little smoother is to educate the pro se litigants as to the process. And I think that education, because they have a vested interest in their case, that education is well received and well implemented. I've watched pro se litigants try their own cases and cross-examine officers pretty well. So I think work ethic to get up to speed, and then some education for the pro se litigants to help bridge the gap.
And we have less than 2 minutes left, Judge Baca.
Mine's sort of a follow-up on Ms. Martin's question about self-represented litigants. I'm very interested in how you would deal with them apart from criminal prosecution, a normal domestic violence case, custody case, because those are heated, charged cases. They become emotional, and often the litigants don't understand that they need to stay cool, calm, and collected because it's emotion.
Yes.
It overwhelms them. And so I'm interested in how you're going to deal with those types of situations and maintain the decorum of the court. And then how are you going to make those litigants feel like they're going to get a fair shake? Because another issue that we confront or deal with a lot is procedural due process. Where people come into a courthouse, beautiful building like this, you feel, oh my God, I'm just Joe Nobody, and I'm going to get just railroaded when I walk in there.
Sure.
So how are you going to make them feel like, okay, no, you're not. I'm here and I'm open to you.
Sorry, Judge. And you only have 30 seconds to respond, sorry.
Too long.
Okay.
Sorry, Judge Baca.
Thank you for the question, Judge Baca. What I can tell you is educating the pro se litigants, but also it's how you communicate to the pro se litigants. The judge has the ability to set the tone in the courtroom, and certainly I've been before many judges who have set a very reverential tone, and I have been before those judges who make their direction of where they want their courtroom to be without question, and everyone in between. So I think the judge, as the tone setter, can play a huge role and can educate the pro se litigants as well.
Great, thank you, and that's time. Thank you so much for your application, Mr. Cortez, and your time here this morning. You're welcome to stay and watch the remainder of the interviews if you so choose.
Thank you very much. Thank you all.
Good morning, Ms. Dickey, and welcome.
Good morning, all. Thank you.
You have up to 5 minutes to make an opening statement if you so choose. I will keep the time and limit it to 5 minutes. At this point, the floor is yours. Welcome.
Thank you. Good afternoon, everybody. My name is Kristen Dickey, and I was born and raised in Hobbs, New Mexico. I graduated Hobbs High School in 2002. After I graduated high school, I went to the University of New Mexico in Albuquerque, where I went to undergraduate school and law school. In 2013, I began my legal career as a public defender in Lee County, and then I went to Santa Fe County. As a public defender, I zealously represented indigent clients in various criminal proceedings in magistrate court and in district court. I also had the privilege of representing sex offenders at sex offender review hearings in front of the parole board. In 2018, I married my husband, and we decided to move back to Lee County to start our family. Lee County is our home, and even though we love northern New Mexico, Lee County is where we want to be. When I returned to Lee County in 2018, I became an assistant district attorney with the 5th Judicial District Attorney's Office. And even though I was still practicing criminal law, I found being a prosecutor rather eye-opening. As a public defender, I was an advocate for my clients. However, as a prosecutor, I was a true minister of justice. And in my role as a prosecutor, my job was to find the truth, not convictions. To make sure that the victim's rights were abided by, as well as the defendants. I really enjoyed that job, but then I decided to broaden my horizons and learn a new area of the law, which is why I took a job with the Children, Youth, and Families Department. I have been a children's court attorney with the Children, Youth, and Families Department since 2019. I then became the managing attorney for the Southeast region in 2022, and I am still currently in that role. The Southeast region does consist of Harding, Quay, DeBaca, Curry, Roosevelt, Chavez, Eddy, and Lee. And so it is a pretty big region. I manage a group of several attorneys, a paralegal, and several legal secretaries. And I also work still as a children's court attorney representing the department in abuse and neglect cases. That position has been rather rewarding, and that I am able to help children and families. And I have also been able to grow in my role as a supervisor. I am excited to be here today. The role of a judge has been one of my childhood dreams. So thank you for having me here. I look forward to sharing my qualifications and my experience and answering any questions you may have. Thank you.
Thank you very much, and we will begin questions with Judge Baca.
Well, thank you for your application. I appreciate your prior experience in the public defender's office as well as the DA's office and now doing the abuse and neglect cases. And I think that's going to benefit you if you should become a judge because of the general jurisdiction that the district court judge has. However, in going through your application, I did see that there were 2 areas where you really don't have much experience that are probably very important for a district court judge to get that experience and have that experience, and that's in the area of personal injury and commercial law. So take a moment and tell us, if you will, how would you get up to speed in those areas when the first personal injury case hits your desk and you're like, oh, motion for summary judgment, motion to dismiss on these issues, how are you going to get up and ready for that?
So you're absolutely correct in that I don't have any experience in personal injury or commercial litigation. However, I have learned a new area of the law, and in doing so, I took these skills that I have acquired as a law student and as an attorney in general to learn the new area of the law. And I know that I can learn a new area of the law rather quickly because I've done it. I've took criminal law practice in law school. I did an internship. I also did another internship, or I did clinic in law school. So I have extra years of that practice, and I did various types of law as a clinical law student. Luckily, the University of New Mexico did give me the tools necessary to know how to research, write, and then also be in the courtroom. I also feel that I can, I've gathered my own way of thinking because I knew that this question was going to come up, and that I will read the motions. I will research the law, and I will also look to the attorneys to answer questions. But there's no doubt I know how to research any type of area of law and apply it accordingly.
Thank you.
Thank you. Ms. Martin?
Your practice has been through government agencies, and so from what I saw, there wasn't any experience in private practice. How do you feel suited to be on the bench without that experience and how to handle attorneys who are in private practice coming before you, and some of those unique issues that we face with our clients when coming in front of you?
So even though I have not worked with the private law firm, I have dealt with attorneys that do. As a prosecutor, I dealt with several attorneys that have worked for private law firms, and then also I work in my role as a children's court attorney with various private attorneys. The private attorneys have contracts, and then we also have assignments to these private attorneys. So I think that I can manage that situation. I've done it before, and so I don't think that it would be an issue coming up in my courtroom.
Mr. Collins?
Thank you for your application. In the role as a judge, you'll be doing more than just running your court and the cases that come before you. Could you address what you would see your role in the larger context of now being a judge in the community of Lee County?
So as the judge, if I were to be given this opportunity to be the judge in this district, I plan on doing a couple of things, and that is one, to administer justice. I think that I bring a unique perspective in that I have worked with sides and defense and in prosecution. I also plan on bringing efficiency and order. One of the reasons, however, that I want to be a judge, not only has it been my dream growing up, but I also want to give back to the community, and which helped mold me. And so I feel like I want to give back to the community. I want to be an inspiration to my community. And so that is what I see myself as in a larger role, is to being that role model and to also bringing efficiency, justice, order, etc.
Thank you.
Mr. Jennings?
Ms. Nikki, following up on the Honorable's comments about your personal injury or criminal experience, I saw that you worked for Ron Bell as a legal secretary. I would figure that would be a lot of experience.
And so I wish.
Yeah, I'm just kidding. You know, there's a lot of partisan politics out there. There's far right, far left. I consider myself more in the middle of the road. And I think most middle of the road Americans see the same thing. The courts, we see a lot, you know, the Supreme Court. We see a lot of stuff on the right and the left. And I think it's important that the courts are fair and impartial, and that the judges are collegial to all parties concerned. How would you run a courtroom to make sure that you were fair and impartial and collegial to all parties?
I think that Chief Justice Roberts said it best in his Senate confirmation hearing, and that he will always remember that it is his job to call balls and strikes, not to pitch or bat. And I really like that statement, and that I feel that it gathers the essence of what it means to be a fair and impartial judge. To make rulings without fear or favor. And so I would run, as a prosecutor and as a children's court attorney, like I said, it has been my role to find the truth, not get convictions. And so I have had to look at cases, not from the perspective that I would win a case for my client, or win a case for a victim, but to be fair. And I have been in those situations where I've had to dismiss criminal cases, or I've had to tell my client, there's not enough there to terminate someone's parental rights, or there's not enough there to move forward with, you know, moving a child from a home. So I will handle it kind of like how I've handled it as a prosecutor and as a children's court attorney, a true minister of justice, and following the law.
Thank you.
Ms. Curley?
Can you give an example of incivility in the courtroom or the practice that you personally had to deal with, and how, as a judge, you could prevent such occurrences?
What was the word? Instability?
Incivility.
Incivility. Well, I've dealt with a lot of incivility throughout my years of practice, unfortunately. And so the way that I have handled those situations is that I try to be the bigger person and maintain my temperament, maintain my composure, and to always be professional. And that is one thing that if I am given the opportunity to be in this position, that there will be order in the courtroom. I will not tolerate any type of that behavior. And so I think just, you know, my personality, my experience, and my feel that attorneys are in a, what's the word I'm looking for, are in a higher role, that I have to behave accordingly. And I like I said, I will maintain order in my court.
Ms. Luce?
Good afternoon.
Good afternoon.
Kristen, good to see you. Thank you for applying. The Supreme Court has allowed a pilot program of settlement conferences for criminal cases. And what would be your thoughts as a judge if you are nominated to that position for being innovative and how to resolve what I call the backlog of cases from COVID that we have waiting to be tried?
Well, I know coming in, and I've been in front of several judges throughout the Southeast region, so I know that this is not unique to just Lee County. I know that there is a backlog in the various counties that I've practiced in. And so I really thought long and hard about this issue, and even though I'm not practicing criminal law, I know through my 6 years of experience that that is a pretty big docket. And so my plan is to bring my own systems and processes to the courtroom, as I've done as a supervisor and manager in the Southeast region. I really feel that pretrial conferences are not utilized in the way that they should be. Oftentimes counsel will come up and say, ready for trial, when in fact they're not ready for trial. Discovery hasn't been provided, pretrial interviews haven't been scheduled. And so last minute jury trials are being continued and there's a backlog. And so I plan on, one, utilizing pretrial conferences in a more productive manner. I also would like to do more attorney-judge meetings. I don't know what happened to brown bags. I haven't been invited to one. So I really like that, so that we could have a communication amongst the attorneys. What are the issues that you're facing and how can the court help? I think that this is a really good idea, the pilot program, and having these settlement conferences. I would be completely supportive of that. And then also fast track dockets. I don't know if there's any way that we could do some types of cases, because as you know, with possession cases, sometimes those can move a little quicker than others, or there's some other type of cases that can move quicker than others. So I would totally be in support of that. I have plans to implement systems and processes, and so that would be my goal.
Mr. Stout?
Yes, thank you for your application. In our society, we seem to have a lot of real strong, as Mr. Jennings pointed out, political division. How do you think a district judge should balance their personal beliefs and political beliefs against the rule of law?
Like I said earlier, I think that it's absolutely mandatory that a district court judge put aside their personal and political beliefs. And I think that I have shown that I am able to do that by being able to represent both sides. Like I said, I have, as a public defender, I represented some serious violent offenders, and I was also in charge of responsible for representing sex offenders that had been convicted of sex crimes, and then had to go in front of the parole board to then get off of parole. And so I was easily able to do that because I understand that we have laws, that people have rights, and I have no problem doing that. And then also on the other side, I have no problem as a prosecutor being able to make sure that defendants' rights are making sure that respondents' rights as a children's court attorney were upheld. So I know that I can be fair. I know that I can be like Chief Justice Roberts, and that I can make decisions free of fear or favor.
Ms. Laurel?
You talked about a passion for wanting to be a minister of justice, and you touched on some things that you would do in your courtroom. Do you have anything else to say about what would be the most powerful tool or piece of power that a judge holds to ensure that justice is achieved?
I think it's just the overall decision. I mean, I've been in several courtrooms, and I will say that it's very, it's just a good feeling when a judge follows the law. And you know that you're going to go in front of a judge that will follow the law. And I'll say we have some pretty good judges in this county, and several of them have been an inspiration to me. And so I have been given the opportunity and privilege to practice in front of a lot of great judges in this county, in the southeast region, and then in Santa Fe County. And so I would kind of pick up on what I have learned from them in being professional and respecting everybody in the courtroom. And then in my decisions, being fair. And so I think it'd be fairness, respect, and professionalism.
Mr. Mills?
Everyone has as you've talked about rights quite a bit, a right to a fair, full proceeding in front of a impartial tribunal. Can you talk a little bit about what that means to you, that particular right, how we would see that applied in your courtroom, and how that may look to an external observer in a courtroom that you would manage?
Well, like I said, it's all about calling those balls and strikes, and I think that that's how you level the playing field in any type of courtroom proceeding, and making sure that all of the procedural safeguards and laws are being upheld. And so, I mean, it's just making sure that you are, one, knowledgeable in the rules of law, and two, applying them accordingly. And so I have a lot of courtroom experience. I've done jury trials. I've done, I don't know how many bench trials. I think I was being very conservative in looking back in my application on my experience in that area. And so that is what, so I'm able to, I was the one pitching and batting, but I'm also the one hearing those rulings. And so I imagine that it would be a fair and full, fair proceeding, and that I would make sure that all of those procedural safeguards are abided by.
Ms. Green?
Thank you. Thank you so much for your application. My question relates to somewhat to the backlog that Ms. Luce mentioned. I'm an attorney. I practice mostly on the civil side, but all attorneys right now are busy. The judges are busy. My question for you is, do you have any practical steps already in place or thoughts on how you can keep cases moving and be able to make a decision, particularly from my perspective on the civil side, where you're dealing with motion for summary judgment, and being able to issue a timely order in those types of situations and other cases to keep them moving?
Well, like I said, I've thought long and hard about this, and I do, the examples that I gave on the pretrial conferences and attorney-judge meetings. Those are just some of the ideas that I have in place. I am a very organized person. I am the type of person that gets things done, and I get it done now. And so anybody who knows me can attest to that. I don't like having things waiting around. And so if as in your case, you're waiting on a ruling, I do plan on getting rulings out rather quickly, because I just have that personality where things cannot sit around for long. And so that is one thing that I would be able to do, is make sure that you get those rulings. I know that the effect that having a backlog, having a high caseload has in this area, and that I have experienced it, so it's something that I take very seriously. As I've said, I'm in charge of the whole Southeast region for CYEFD, and I have implemented my own systems and processes into making sure that motions are timely filed throughout the region, making sure that they are set as soon as the court can get them set. And so we don't have our children waiting around for, say, a termination of parental rights hearing. So I've done everything that I can to implement those processes. And as an attorney, if I see an issue, like I said, I try to address it right away, and that's something that I would also implement as a judge. If a ruling needs to be done, I'll get it done. If a hearing needs to be set, we'll prioritize, settings that are high priority. So hopefully that answers your question.
Mr. Ragsdale?
Thank you. Good afternoon. What do you believe is your greatest success or accomplishment as an attorney, and how would that benefit you if you were selected to serve as a judge?
I think that my greatest success as an attorney is just making my clients happy and getting justice. As a public defender, that was a very difficult position to have because many of your clients would at times would be called a public pretender and stuff, and they're not as appreciative, right? You're a free attorney. And so at one point I had 180 cases, and that was throughout this entire jurisdiction. So Lovington, Tatum, Eunice, and Jow. And so I'd have to travel all the way to Jow or Eunice or Lovington for my hearings. And that was difficult. That was very difficult. And I was able to maintain that caseload and keep my clients happy. And so that was one of my greatest accomplishments because that is very difficult to do. I would say just being an attorney in general and being able to give back to my community is equally as great because as a children's court attorney, I have been able to help children, but then also reunify families, help reunify families when able to do so. And so that's a great feeling. And so I guess I'd just say in general, my work as a government attorney has been my greatest accomplishment, and I have really been able to impact lives. I mean, even as a, doing like criminal sexual penetration cases and getting wins on that, it was absolutely necessary. Was, it's a good feeling to get justice for a victim. So I say all around, just being able to be in this position as an attorney, as a government attorney has been a great accomplishment.
And we have 4 minutes remaining. Judge Kirksey?
Kristen, what are some flaws that you would need to overcome to be a good judge?
My flaws is my perfectionism. I am a perfectionist, and I will say that has caused me a great deal of stress personally. I feel that, I don't take it out on anybody, but as an individual that has affected me personally is being a perfectionist and being able to get over those imperfections. And so I would say that would be my biggest flaw.
Justice Vargas?
Good afternoon.
Good afternoon.
My question is also related to the rule of law. One of the new challenges that's faced by the judiciary these days are citizens and litigants who come to the court and sometimes don't come to the court and either flout or challenge the rule of law, challenge the authority of the judge and the judiciary. And so my question is, what experience do you have and how would you handle the circumstance where your authority as the judge is challenged either by the litigants or by the public?
I will tell you this, that I was raised in a very strict household, and that you respect your parents, you respect your elders, you respect authority. And that's something that I take very, very seriously, and that I respect my supervisors, I respect judges, I respect everybody. And so I demand respect. I would, like I said, have order in the courtroom. And I would probably just give a warning, a very stern warning, and usually what I have seen that usually does the trick, but I would demand order and respect in the courtroom because I, too, would be orderly and respectful to anyone that comes into my courtroom. Thank you.
Commissioners, we do have, those last 2 questions were very efficient. We do have 2 minutes left, so if anyone wants to ask a quick question, we do have time for that.
I'll follow up with my question about the in domestic relations and private practice, the expense of litigation. As a judge, how do you see managing that for parties when the expense of litigation is a huge hurdle for our clients in private practice?
So that is something that I would have to research. I know that in criminal cases, fees can be waived. And so I don't know if that would also extend to your domestic relations cases. That's something that I would have to look at to see if I could do it. if I could do that, I would. Because I understand, I mean, a barrier to justice shouldn't be financial, your financial ability to pay. There shouldn't be because your financial ability to pay. I've also seen implemented in the past payment plans in criminal cases when it comes to fees. So I don't know if that's also something that the judge can utilize in the domestic cases.
Thank you so much for your application and your time here this afternoon. You are welcome to stay and watch the remaining interviews.
Thank you.
Thank you. Commissioners, we are running a little bit early, 10 minutes early actually. Let's take a 15-minute break. If we could reconvene at 2:35, please. 15-minute break, reconvene at 2:35. Thank you. Welcome, Ms. Kirkendall. Thank you for your application. You have up to 5 minutes to make an opening statement. If you so choose, I will keep the time and I will cut you off at 5 minutes. At this point, the floor is yours.
Thank you. Good afternoon. I'm honored to be before you today. My name is Lisa Kirkendall. I've been a licensed attorney in New Mexico since 1998. I was first licensed in Oklahoma in 1996. I've lived here in Hobbs for 10 years now. All of my boys graduated from Hobbs High School, and my husband currently works for the city of Hobbs. I was a prosecutor for 19 years before beginning my work with New Mexico Legal Aid. My courtroom experience is extensive, along with my jury trial experience, which I believe will benefit me on the bench. Since working with Legal Aid, I have handled restraining order hearings, domestic relation cases, including child custody and divorce. I've also handled kinship guardianship cases, housing issues such as foreclosure and evictions. I've also done termination of Social Security benefits as well as Social Security disability benefits, as well as unemployment cases. I've learned a great deal from the wealth of knowledge of the attorneys that work at New Mexico Legal Aid. We have some absolutely brilliant attorneys, and I've had the pleasure of learning from them during my time working there. And I would like to use that knowledge now on the bench. Looking back on my career, and now that my kids are raised, I feel I have a lifetime of experience to offer to the legal community, and am in a great position personally and professionally to do that. I also believe my experience working with clients that will be pro se in court has also given me a different perspective and more patience. The courts see a great deal of individuals representing themselves, and I believe my experience will be a benefit for that situation. I appreciate your time this afternoon, and I believe I have the experience and qualifications to have my name sent to the governor, to have the possibility of having the honor of continuing to serve Lee County as a judge for the 5th Judicial District. Thank you.
Justice Vargas, you have the first question.
Good afternoon, Ms. Kirkendall. Thank you for your application, Kirkendall. I have to ask you about your answer to question number 34 on the application, which is the question about being named in a lawsuit. And you referenced a couple of names. You mentioned foreclosure in Farmington, then you moved to Las Cruces. And then you mentioned a couple of collection cases. I looked those up. I found a third that looks like maybe it wasn't served on you. The last one having been satisfied just last October. Can you tell us a little bit about what was going on, whether that's been resolved, what assurances you can give us that we won't have one of our judges being sued?
The home in Farmington was, oh my God, I don't even know how many years ago that was.
2011.
Okay, thank you. So, but my math's terrible. We relocated from Farmington to Las Cruces, tried to sell our home, were unable to, ended up renting it out. That was a nightmare. And we just, with the relocation and, trying to raise 3 kids, and my husband struggling to find a decent paying job in Las Cruces, life happens, and it was best to let it go into foreclosure instead of trying to continue to struggle. And as far as the collection, same thing. My husband went through some serious medical things. He tore his Achilles tendon, could not work at all for 6 months, and then a year and a half later, suffered a heart attack. So with just different things that happened, again, I had 3 boys, and boys are not cheap, especially when they're involved in sports. And sometimes, you know, you just get behind on certain things. And I feel, I don't think it's necessarily a detriment, because I think it makes you a little more empathetic to the people that come in front of you. Because everybody that walks in this courtroom, 1, they don't want to be here most of the time, and 2, they're struggling also. And I think when you have a judge that's been in that position, they have a little bit more understanding and can relate to the people in front of them a little bit better than other people that have never had those struggles.
Thank you. Judge Kirksey? You have extensive experience in criminal law, absolutely. You talked about the amount of jury trials that you've tried. I think a lot of people think that that's most of what we do up here. And although that's how I spent yesterday, it wasn't how I spent about the 3 or 4 days before that. You know, it might be hearing an actual divorce case, or doing an adoption, or hearing an oil and gas case, hearing a personal injury suit. And I'm just wondering, without that in your background, how do you intend to kind of get up to speed and be comfortable dealing with those cases?
Well, and that's something I've had to do for the almost last 5 years, is learning types of law that I've never done, with doing the domestic relations, divorces, child custody. And so the biggest thing is you have to research. So you have to prepare yourself for every case, even if it's a criminal case. Just because I have experience doesn't mean I know what's going on in that case. And so I was able to be doing research and honestly relying on the judges that have more experience in those areas, and being able to ask them for some guidance and, you know, what would be the best course of action. But I honestly think research and reading is going to be the biggest. Reading that case law and brushing up on that different type of civil law that I have not done.
Thank you. Mr. Rexdale?
Thank you. Good afternoon. Why, at this point in your career, would you seek to become a judge?
One, I think it's because I've always aspired to be a judge. And now that I do have some civil experience, and I think the biggest thing is I'm in a position now where I don't have the same responsibilities I used to have, that I'm in a better position to take the bench. Raising children is difficult and very time consuming. And I have, like I said, I had 3 and they all did sports, and I'm in a position now, they're all grown, and I don't have the same drain on my time as I did prior. And so I think I'm in a position now where I can really dedicate full time to being on the bench, as opposed to, oh, I've got this at school, I've got it, you know, that type of stuff.
Ms. Green?
Thank you for your application. My question relates to attorneys being busy, judges being busy. What are the practical steps that you can take as a judge to make sure your cases keep moving? And especially like in the civil cases, which I deal with quite a bit, and making sure orders get issued timely, decisions get made. Do you have some practical examples or steps that you plan to take to keep those cases moving?
That is something I would definitely have to put into place, because I've noticed that since I've been in doing civil stuff, is sometimes you file an emergency motion and it's 3 months later. So I think one part of that is you have to have the staff that is there and also on top of your cases and reminding you, hey, we've got to get this in weekly, check your cases and see if there's something you need to do in those cases. I mean, we run a case list sometimes at Legal Aid, we sometimes do it at the DA's office, and just see where your cases are at and make a to-do list if necessary, so that you are staying on top of that.
Mr. Mills?
Everyone's entitled to a full, fair public hearing and an impartial tribunal. Comment a little bit on that and what that means to you, and what would that look like in a courtroom that you would be running?
I think the biggest thing in a courtroom is you have to show everybody that walks in front of you respect. And and the courtroom does need to be open to the public, unless, of course, there are certain situations where it has to be a closed case. But having the courtroom open, and always remember that you're there to serve the county, Lee County. You're there to serve everybody in front of you, and you have to treat them with the respect that they deserve and keep the decorum in the courtroom. And anybody that wants to come watch a case should have that opportunity to come into the courtroom and observe what is going on.
Ms. Laurel? Okay, you said you'd always dreamed of being a judge, so I kind of have a two-pronged question. How do you feel that as a person, you will be more fulfilled personally being a judge than you are as an attorney? And how will your being on the bench serve the community better than you can as an attorney?
I think for me personally, I think most of us, when we went to law school, we have these visions of what we wanted to accomplish when we were going to be lawyers. Mine was honestly to be a prosecutor. I did that for 19 years and burned myself out, honestly. So I think to me, after doing civil law, the next step is to be a judge and to be able to treat people, because there's times you run a courtroom that you see people not treated the way they should be or talked to differently because they're not represented as opposed to being represented. I would like to be able to treat everybody the exact same, whether they're represented or not. And I think at this point in my life, I have that temperament to do that. And to me, it would just be fulfilling something that I wanted to accomplish. So accomplishing a goal you set for yourself. And I'm sorry, the second prong. Oh, how will it fulfill me as opposed to being a lawyer?
Yes.
I think in some ways you can do more. I mean, you can serve people more as a judge than as a lawyer, because you're only working with who comes in front as a lawyer individually, what cases that legal aid gets, but as a judge, you're going to be helping whoever walks in front of you, whatever case it is. And you can do a much wider variety of cases where you could potentially guide through people through the system or make decisions on those cases.
Mr. Sapp?
I'm familiar with you when you were a prosecutor, but I'm interested, what did you learn from your experience in legal aid that you think will assist you in becoming a district judge?
I think one of the biggest things, honestly, I've learned is some people, whether you ultimately can do full representation, is they want to be heard. And I think sometimes as a judge, you can give them that opportunity, especially if they're a pro se litigant. You can give them the opportunity to be heard. Even if you're potentially not going to rule in their favor, you can soften the blow of not ruling in their favor by how you deliver your ruling. And I think that's the biggest thing I've learned is that there's so many people they want to know that somebody listened to them.
Ms. Luz?
Good afternoon. The Supreme Court implemented a pilot program for criminal cases where settlement conferences were allowed. And we have a backlog, or I think we have a backlog since COVID of cases. I know it's all areas of law and with the courts. But what innovations or ideas you kind of thought about that you might be willing to try as a judge to help with the backlog to see cases get moved through the system?
I think one of the ways that you can deal with that is either, depending on how bad the backlog is, either once every 2 weeks if your calendar allows for it, or once a month you have basically a status conference and see where those cases are. And the attorneys need to come to that conference and say, this is where we're at with the settlement conference, and keep them moving and report back each month where those cases are at so that those can be settled and moved through the court system.
Ms. Kirtley?
Okay. I've asked this question to everyone, but you in particular, I know specific instances where you've had to deal with incivility in practice, and how do you think, as a judge, you could prevent such occurrences from happening?
Are you talking from the litigants in front of you or the attorneys?
I think all of the above.
I think the biggest thing is, as soon as somebody is beginning to become, especially attorneys and professional, as a judge, you have to step in and shut it down. And when potential litigants are becoming, uncivil and acting out, you have to rely on your bailiffs to tell them, if this is going to continue, we're going to take a break. You need to calm down. You need to act a certain way when you're in a courtroom. And there's a certain decorum that's expected in the courtroom. And I think if from the beginning you express to the attorneys that appear in front of you what you expect in your courtroom, the decorum, and that they pass that on to their clients. And then hopefully, when people come in, they know what's expected of their behavior in the courtroom.
Mr. Jennings?
Good afternoon, Ms. Kirkendall. In our community, and I'm gonna ask the same question that you have everybody else, that I've met, the previous applicants. In our society, there's a far left, there's a far right, politically, social media, and the news media, and most Americans probably aren't in the far right or the far left, and we get lopsided news. There's a lot of animosity. Courtrooms, I think it's important. You've talked about the people without much means, and some of us, most of us have been there, and so there's some empathy there, and I'm glad to understand that you would have that empathy because it's important, so you understand that. But when you have a courtroom, you need to be fair and impartial and collegial to all parties, whether they're litigants or the counselors. How would you operate your courtroom to make sure that you were fair, impartial, and collegial to everyone?
Well, for me, you have to, I think, constantly remind yourself that everybody's equal in your courtroom and everybody deserves the same respect, no matter what your personal feelings are. And that's an important part of being a judge, is you have to set aside your personal feelings, be fair and impartial, and I think treat every litigant and counselors the same, and put aside whatever your political beliefs are, because there's no room for that, I think, in the courtroom. And you just have to remind yourself of that constantly. And if you have to take a break to go count to 10, then that's what you have to do, to let yourself settle down, or anybody else in the courtroom that needs to take a breath.
Thank you.
Mr. Collins?
Thank you for your application. My question has to do with outside of the courtroom. If you were to be selected as the judge, that is regarded, I believe, by most as a much more honorific and influential position than a lawyer in criminal cases or civil cases. And recently, in recent years, especially in the pandemic, there have been some legal issues that have been highly contentious, and a lot of public debate around, for example, the governor's public health orders and their enforceability. Those did get appealed and were settled ultimately by the Supreme Court. And so in a specific case like that, or in a more general situation, what would you see your role as a judge in expressing your ideas, opinions, educating the public about significant legal issues?
I think your role as a judge is if you're invited to different organizations to speak, you have to keep it to what the order is. In that specific instance, the public health orders that were issued by the governor, and just reiterate to the public that that's what is in place right now. And it's similar to whatever the law is. You have to abide by what the law is and what the specific orders are at this time, and remind people we don't always agree with the law or orders that come out, but in order to maintain peace and civility, we have to abide by them. And I think when you're asked about it outside the courtroom, you just have to reiterate to people, I abide by what the law is, or what the orders from above are, and that's what we all have to do.
Thank you.
Ms. Martin?
Thank you. Thank you for your application. My question is going to go towards your answer number 18 about domestic relations law. Can you be a little more specific on how many cases, divorces or custody cases you've actually taken to, a merit hearing?
Divorces, I believe in the last 4.5 years that we've done 3 where we've actually gone to hearing and had them resolved. Custody cases, I have done where we actually had a full-blown hearing, 2 or 3. I would have to double check like the cases. A lot of, honestly, what I've done with custody and or divorce and child custody is advice and counsel, because, I mean, there's only me in Hobbs, there's only one attorney in Roswell, and we cover the entire Southeast. So unfortunately, we just we don't have the capacity to do full rep in divorce cases. So a lot of times it's giving them advice and counsel, explaining the process, and then they call back after they have a hearing if they don't understand an order, and we continue to advise them about what the order means, what next steps they can take, potentially arguments they could present in court. But as far as ones where I've actually handled, I believe it's like 3 divorces and 2 or 3 custody, I couldn't tell you for sure. And then I have several pending right now where I've had a couple of different hearings, but we haven't had the final merits hearing.
Judge Baca?
Thank you. My question has to do, touching back with dealing with pro se litigants or self-represented litigants, because when I first started practice, there were very few of them. And now there's a lot of them. And often I think it's because you can't afford an attorney. And so you end up in situations where you have either one side or the other being self-represented, or maybe both of them, especially in divorce cases, domestic relations, custody cases, those sorts of things. They become contentious. They don't follow rules. Sometimes they get emotional. So the question is, I think you have some unique experience in dealing with individuals like that because you're advising them. But now you're going to be the judge in terms of dealing with them in the courtroom and trying to get them to maneuver through the system. So how are you going to deal with them in those situations?
I think the biggest thing is, one is at times you're going to have to remind them how you're going to behave in the courtroom. And one of those things is not interrupting the other party when they're trying to present what they want to present. If they do interrupt, try to shut it down. And you obviously can't give them legal advice, but try to remind them this is what you were instructed to do. You need to get that done. Next time you're in front of me, I expect that these things will be done. And I think, but delivering it in a way that's not necessarily harsh, but reminding them you have to follow through on these things that you've been ordered to do, and remind them what the potential consequences can be. Because we deal with that where they contact us, they want advice, you give them all the paperwork, all the information, they call you back 2 or 3 months later and they've done nothing. They didn't file anything, and now what do I do? And you got to file it. You've got to take the first steps. And I think it's just reminding them in the courtroom, because it's overwhelming. It can be overwhelming for us as attorneys when you get a case you've never dealt with before, like, oh my gosh, and just to remind them kind of baby steps, like this is the next step I expect to see, and the next time in front of you, now this is the next step I expect to see, but just trying to maintain calm in the courtroom, so hopefully they remain calm, which I know doesn't always happen. But.
Commissioners, we have 7 minutes left, so we have time for more questions.
I have one follow-up.
Yes,
And
great.
it's on, I like that phrase, people want to feel like they've been heard. Win, lose, or draw.
Right.
They want to come in, feel like the judge is open to their argument, is listening to their argument, and considers the argument in making their decision. So how are you going to do that?
I think one of the biggest things you have to do as a judge is budgeting your time. And you have to make sure when you set a hearing, which again I know is not always easy, well, all of you that have cases, I know Judge Kirksey, but making sure you've allotted enough time so that you can listen to them. Because, I mean, when you've got, as an attorney, you've got 15 other cases, or you've got other phone calls you have to make, sometimes you do kind of rush through that. I think the biggest thing is making sure you've set aside enough time to kind of building contingencies if something kind of goes awry, and giving them that opportunity to say what they need to say. And of course, there'll be times you're gonna have to say, that's enough. This has nothing to do with what we're talking about, that's enough. But trying to budget in that time. And I know it's probably sounds a lot easier than it is.
I'll tell you what she's referencing. So Ms. Kirkendall has a hearing with me that was set for in the morning. And now something else has developed in the case, and evidently they're asking for a continuance. And so I'll tell you, that's one of the biggest frustrations
Yes.
I have as a judge. And Ms. Martin can tell you this, because she does domestic hearings in front of me. When we do a scheduling conference, I say, if you're gonna ask to continue this, please do it at least 14 days in advance.
Right.
So I can offer that time to another case. So how would you as a judge manage those requests for continuances and scheduling?
I think you have to reiterate to the attorneys, every time you ask for a continuance, now I have nothing to do during that, 2 hours or whatever I gave to you.
Oh, believe me, you have plenty to do.
Right, well, but I mean, I don't have a hearing at that time. So, I mean, you reiterate to the attorneys, every time, I get a last minute continuance, that's court time that I'm no longer utilizing. So then when you get the next complaint is, well, it's taken too long for this case. Well, how many continuances have you filed? So it will be, I think, a very different look from the bench than it has been as an attorney. And when I've had friends that take the bench, they say like a jury trial from the bench, very different look than when you're in the trial itself. So it sounds easy, I know. That's why I referred you to, manage your time. I think that you just have to remind the attorneys, like, I understand you need this continuance. And I think you have to make sure it's a valid reason. And I know that you do that, but it can't be a continuance for something simple that should have been resolved, or, I stubbed my toe, or, I need a continuance. You need to make sure they're valid continuances.
Thank you.
I have want to steal Ms. Martin's question from earlier. You've always worked in government law. To me, my rates are bargain basement. To my client, it's a small fortune. How do you manage how will you look at, because you haven't had clients that are like, we're sitting here for 2 hours, I'm probably paying you, what's up? We have that on us as private attorneys, that you haven't experienced. What can you say about how you would understand it, and how you can strive to make that a good experience for the people who are paying their attorney?
So are you talking about like on a trailing docket, or just?
A trailing docket would be a great example.
Okay.
You have one case of 163.
One of the things I've seen that some judges do, which I think is helpful, one, you do the interpreter cases first, because that's a significant amount of money coming out of the court's budget when you're paying the interpreters. And then do the private counsel next. And then, which, it's really hard though, because then you got the pro se people sitting there like, well, I don't matter, I've been here for 2 hours, so yeah, it sounds really great when you say it in your head, then when you say it, you're like, holy cow, how do you do all this? I think you just have to learn to balance it. And in some ways, you have to learn it as you're doing it while you're on the bench, because I haven't been in that situation. So it's hard to really give a concrete answer, but I think you have to balance. And if you only have one private attorney case, then you can do that one. But if you've got 5, then you kind of have to balance which one's going to take longer. And the ones that are going to potentially be the longer hearings, I think they do have to go towards the end of the docket, so that you can get through the ones that aren't going to take as long, and then have the contested hearings at the end. I think sometimes that's the most fair way to do it.
We have 1 minute and 45 seconds if anyone has a very quick question.
Or you don't have to ask me.
Okay, hearing none, thank you so much for your application and your time here this afternoon. will now entertain motions and discussion with regard to how the commission would like to proceed with deliberations about the candidates. We can proceed in open session or in closed session. If we deliberate in open session, our deliberations are watched by the candidates and the public. If we deliberate in closed session, the applicants and the public are escorted out of the room. In closed session, we would use straw voting and then come out of closed session for a public open vote where everyone's vote is recorded. The vast majority of judicial nominating commissions have happened in closed session. We make this decision regarding open versus closed session by vote. We would need a motion, a second, discussion, and then a vote. If the commission decides to proceed in closed session, we would then vote on the level of confidentiality. The commission could vote for either total confidentiality or partial confidentiality. With partial confidentiality, the candidates can be given general feedback by the commissioners without providing specific details about what particular commissioners said or how particular commissioners voted. At this time, I would entertain a motion for an open or closed session.
Dean, I'll move that we proceed to closed session.
Thank you.
I'll
Is there a
second it.
second?
I'll second.
Thank you. Discussion or questions? Okay.
So, you know, there's no discussion. I'm not a lawyer, I'm a layman. Most of the people on this committee are lawyers. I want to make sure that we get someone that represents the community and they're collegial and there's no animosity. You know, I'll probably ask some questions about some of these lawyers about the candidates and how they think that know them, and ask them about their collegiality. And I think that couldn't be given in candor if it's an open session. I've been on these commissions before, and I think it helps us to make a better decision when we can talk frankly and together to make a decision. Because I think we should try to be unified in our decision.
Thank you.
Thank you.
Any other discussion? I'm going to ask for a show of hands on this vote. So if you are voting in favor of closed session, please aye and raise your right hand.
Aye.
Or left. Opposed? Abstentions? Okay, it unanimously passes. Now that we have made a decision to go into closed session, we need to decide whether we will proceed with total confidentiality or partial confidentiality. Do I have a motion?
I move that we proceed with partial confidentiality.
Partial.
I'll
Thank you,
second.
Justice. Thank you. Discussion.
I was on a commission a year ago, and one of the candidates wasn't chosen, but was positively regarded by the group. And I think the general feeling was it was just maybe a premature time for that individual, and it would be in that person's interest to provide them with constructive feedback for a possible future application.
Thank you. Other discussion? Okay, we have a motion on the floor for partial confidentiality. Again, show of hands and aye, all in favor? Aye. Opposed and abstentions? Again, unanimous. So at this point, the public and candidates do need to leave the room, and the video recording device needs to be. We are back in open session. Is there a motion to be placed before the commission?
I move that we send the name of the following nominees to Governor Michelle Lujan Grisham for consideration in making an appointment for the vacancy in the 5th Judicial District Court. The nominee is Efrain Andres Cortez.
Thank you. Do I have a second?
I will second that motion.
Thank you. All in favor, please signify by raising your hand and saying aye.
Aye.
We need to get the count. Sorry. you. Opposed? Abstentions? The motion passes. The vote will be recorded in the minutes. You got it, Beth? Yep. Great. Is there any further business before this commission?
Move we adjourn.
Is there a second? All in favor?
Aye.
The commission is adjourned. Thank you to Beverly. And thank you so much, commissioners, for your service. We
And
truly
thank you,
appreciate it.
Dan Carey.
Thank you. Thanks, everyone.
Thank you.